Arrested for DUI in Florida, you've only got 10 days to save your driver's license, and if you wait until day 11, it's too late. I'm Attorney Adam, and I'm going to explain exactly what the 10-day rule is, how to use it to protect your license, and what happens if you blew under the legal limit. At my firm, one of the biggest mistakes we see after a DUI arrest is waiting too long to act. The moment that police officer takes your license, a 10-day clock starts ticking. If you miss that deadline, you could lose your license for months, even before your case ever goes to court. So here's how it really works. When you're arrested for DUI in Florida, the cop takes your driver's license and gives you a piece of paper called a notice of suspension. That paper is your temporary driver's license. It lets you drive for 10 calendar days after your arrest. It's basically the DUI ticket. And during those 10 days, you have to decide what to do next with the Florida DMV. And they're officially called the Florida Department of Highway Safety and Motor Vehicles, FLDHSMV. If you do nothing, then on day 11, your license stays suspended. You can't appeal. There's no second chances, really nothing you can do. But if you act within the 10 days, now you have two options, especially if this is your first DUI. So option one is you request a formal review hearing. That's your right to fight the suspension. Think of it as a mini trial. Your lawyer can subpoena witnesses, cross-examine the arresting officer, and challenge whether the stop, the arrest, or the breath test was done legally or illegally. Once you request that hearing, you get a 42-day temporary permit so you can keep driving until the hearing date. Okay? And that's work and home, school, religion, kids, attorney, groceries, medical, anything you need to sustain your life or your livelihood, or the life or livelihood of somebody that you're the primary caretaker of. Now, option two is you can waive this hearing and apply for a hardship license immediately. Okay? And there's pros and cons to both of these. Long story short is you need to have this conversation with your attorney. Okay? There's pros and cons to each, and your attorney should go slow and break these down for you. I believe it's a solid 15-minute conversation, at least, to go over everything about the client, what they do for work, how much they need to drive, because there's a few different factors involved in this. Now, here's another wrinkle where most people get confused. If, by some miracle, you blow under the legal limit, so under 0.08, your license is not automatically suspended by the DMV, so the 10-day rule doesn't apply to you. What'll really happen is when you blow under, or if, right? Because like I said, it's a big if, then the cops are going to miraculously think you're on drugs. So they're going to want a urine test. If you refuse the urine, or if you cannot pee on command, then they're going to count that as a refusal, and they still will try to suspend your driver's license for the urine refusal. If you do give the test, the urine test, then no matter what it comes back with, you're not going to be suspended. So you will not have a license suspension. Now, if it comes back with illegal drugs or prescription medication, you're still likely going to be prosecuted by the prosecutor's office in criminal court, but you're not going to have this at the DMV. So that is a bit of a distinction that can be confusing. And again, another reason why you need to speak with expert DUI defense lawyers. And again, keep in mind that this 10-day window, this is for the administrative DMV section. It's completely separate and apart from the criminal case. So when you get arrested for DUI, two things happen. Think of it as right hand and left hand. Right hand is the criminal case. Okay, you're at the courthouse, you're dealing with a prosecutor, a judge, you might go to trial, you could go to jail. And then on the left-hand side, it's really the only thing that's at stake is your driver's license. So it's administrative in nature. There's a DMV field hearing officer who most of the time is not an attorney. They're definitely not a judge. They're a DMV employee. So keep that in mind. You can't go to jail for the DMV issue, but there are serious consequences because your license can be suspended. So you need to really know and understand the difference between the criminal charge and the DMV case. And when we're talking about the 10-day rule, we're only talking about the DMV case. And so that's why we tell everybody you need to call a lawyer immediately as soon as you get out of jail. And not just any lawyer, you really want a DUI defense expert. I always say there's criminal defense lawyers that pretend to handle DUI cases, and most of this stuff with the DMV, they have no idea what they're doing. So if you're watching this video and you haven't spoken to an attorney yet, make sure that you're asking that attorney. You're saying, hey, teach me about the DMV process. Are you going to handle this, or are you going to make me do everything? Because the real DUI lawyers, we handle everything for you. The criminal lawyers, they'll say, oh, don't worry about the DMV. It's not a big deal, blah, blah, and you can handle it. No, that's completely wrong. That's terrible advice. So if you or somebody you know just got arrested for DUI in Florida, don't wait. You only have 10 days to act, and these decisions can affect your license, your job, and your future. If you found this video helpful, hit like, subscribe to our channel, and check out our next video. And that next video deep dives into the breathalyzer. Okay, what if you blew under the legal limit, but you're still arrested for DUI? Let me tell you, it happens. And this next video breaks that down when the numbers don't tell us the full story. So check it out.